Hello and welcome. This is Lathrop GPM's Employment and Labor Law Update. We're so happy that you could join us, and we're happy to see such a great turnout. For those of you who don't know me, I'm Catherine Nash, and I'm the chair of the firm's Labor, Employment, and Higher Education Group. We had hoped that we would be hosting this event in person this fall with all of you, but that wasn't in the cards. We do hope to see you in person this spring for a full day seminar with breakout sessions and the opportunity for us to connect with each of you in person, which we're very excited to be able to finally do. Assuming we can hold those events safely, please be on the lookout for save the dates after the holidays. Here's a quick overview of how today's virtual event is going to go. Obviously, we're not in our typical Zoom software. We are excited to be able to offer this event through Remo. Some of you might have used this platform before, but for most of you, you probably have not. You'll see it's pretty intuitive. It looks a lot like Zoom and WebEx, which you're probably familiar with. But the feature we're excited to show you is the networking feature. Remo will allow us to do some virtual networking at smaller tables after our presentation. So please stick around, as the rest of our Labor, Employment, and Higher Education group will be joining us for that. It will be a casual opportunity for you to ask any specific questions you might have, or just to catch up with colleagues. Also, if you join us in the networking session after our presentation, we'll enter your name in a drawing for one of 3 fabulous prizes. We'll be giving away an Amazon Echo, a Kindle Paperwhite, and a pair of new Apple AirPod Pros. So hopefully you'll be around for that. I'll be back after the presentation with some more details and instruction on that networking session. A couple of other quick housekeeping notes before we start the presentation today. We do have the chat feature, so please use that if you have questions during the presentation, and we'll do our very best to answer those. We are recording our presentation. We'll be posting on the website about 48 hours after the event. We'll send a follow-up email with a link to that recording, as well as a copy of our slides. We have been approved for CLE for this event in California, Kansas, Minnesota, and Missouri. Important for those of you seeking Kansas CLE, please listen for a verbal code that will be given during the presentation. After the event, our CLE coordinator will be in touch. She'll ask you for your Kansas bar number and that verification code so we can report your attendance. Kansas is the only state that is going to need this code. You'll hear more from me later, but with that, let's welcome our first 2 presenters. Getting us started today will be colleagues Megan Anderson and Rosalie McNamara with an employment law update.
Thank you, Catherine. Good morning, everyone. Thank you so much for joining us. As Catherine mentioned, I'm Megan Anderson, and I'm going to kick us off this morning with an employment law update, along with my colleague, Rosie McNamara. While there obviously are lots of updates besides COVID, I'm going to start by talking about COVID issues, because that has continued to dominate the employment law and HR landscape over the last year, and in particular since early September, when we saw President Biden issue his federal vaccine mandates. I'm going to talk quite a bit about those mandates. There's a lot that we know, and unfortunately there's a lot that we still don't know, because some of the applicable rules haven't been issued yet, though we're expecting the OSHA ETS rule to come out any day this week at this point. So I'm going to walk you through a high-level overview of what we do know at this point. After the presentation, as Catherine mentioned, we are going to be doing networking tables, and we have several dedicated to COVID. And so if you are eager to talk more about COVID issues or have additional questions that I don't cover today, you should feel free to pop into one of those tables. So as you likely are aware, the president issued 2 executive orders as well as an OSHA directive in early September as part of a national COVID strategy that includes a drive to get a much larger population of unvaccinated adults in the U.S. vaccinated. And so there are 4 categories of employees that are going to be impacted by the mandate, with different effective dates depending on whether an employer is covered by a mandate and which of the mandates may apply. We are hearing lots of mixed reactions to the mandates, as I'm sure you are as well. I've heard a number of employers indicate that they had been thinking about doing mandates themselves. And so in some ways, this may be welcome news for them that they get to have the government be the heavy around an initiative that they thought might be a good thing for their organization, no matter what. And then we have lots of employers that are very, very concerned for a variety of reasons, including the makeup of their employee demographics. The more you are concerned about negative employee reaction to the mandates, of course, then the more an employer is concerned, and it's not lost on any of us that these mandates are hitting during a serious labor shortage. And so, we recognize that these pose complications for a lot of employers. There are 4 categories of covered employees. The first is federal workers, and specifically employees of federal executive agencies. They have to be fully vaccinated by November 22nd of this month. I'm not going to drill down into the federal employee requirements, but I will touch on the other 3 requirements today. The second is a mandate for certain federal government contractors with an effective date potentially of December 8th, though in reality, many covered contractors will have a longer time period to comply, which I'll touch on. Then private employers with 100 or more employees are going to be covered by the OSHA emergency temporary standard that President Biden has directed OSHA to implement. That's the ETS that we expect to come out any day. We did get news just this week that the White House OMB had finished its review and approval process. So we are expecting that anytime. Then the final category is healthcare workers at a Medicare or Medicaid participating hospital or other healthcare setting. So if we can move to the next slide, I'm going to start by drilling down a bit on the federal government contractor mandate. This is the mandate that we know the most about at this point because we have both the executive order and then the federal task force that was charged with preparing the applicable rule did issue its guidance document in late September, along with some other guidance materials. So the executive order, again, was issued on September 9th. And then the Safer Federal Workforce Task Force is the entity that has been charged with putting the meat on the bones around that executive order and actually putting in place the rules that are going to apply to covered contractors. Their guidance came out on September 24th. I did include a link on the slide to their website, which has both the guidance on it, and it's important to be regularly checking that because the guidance provides that as that guidance is potentially updated, contractors will be expected to comply with the latest and greatest guidance. That website also includes a memorandum that is to the various federal government agencies that provides them the contract language that they are expected to insert into covered contracts. And then there's a very helpful FAQ section on that website that answers a lot of questions that covered contractors may have. So I encourage you to visit that and wanted to include the link for you in the materials. If we can go to the next slide, the executive order and the guidance provides that covered government contracts and subcontractors include, with a few narrow exceptions, any contract or contract-like instrument with a federal department or agency for services, construction, leasehold interest in real property, or concessions. Covered contracts do not include contracts or subcontracts that fall below the value of the simplified acquisition threshold, which is typically $250,000. It doesn't include contracts with Native American tribes. The mandate does not apply to employees who are working outside of the U.S. If you are a recipient of a federal grant, but you are not actually providing any services to the government under a contract, that is typically not going to be a covered contract. And then the task force guidance says that subcontracts that are solely for the provision of products are not covered. There's a little bit of a question mark around whether primary contracts for products are also non-covered contracts. There's some language in both the executive order and the task force guidance that suggests that only contracts and subcontracts, for services are covered. But we've seen at least one federal government agency, the GSA, take a different position and put out some materials indicating that it can't really distinguish between service and product contracts. And so its plan is to try to insert the new mandate into all contracts. If we can go to the next slide, I'm going to touch now on which employees of federal contractors are covered by the mandate. The mandate applies to any employee of a covered contractor who works on or in connection with a covered contract. So working on the covered contract would be those employees who are actually directly performing work to fulfill that contract. Those working in connection with a contract would include people who may be not doing direct work on the contract, but they indirectly support the contract. And the examples that are given in the guidance are things like human resources employees or accounting employees, or other administrative support sort of overhead functions that are necessary for that contract to be performed. Those employees are also covered. And then other employees who work at a work location with those employees who either work on or in connection with a covered contract are also going to be covered employees. And the only out in that regard is if your workplace is segregated enough that you can absolutely guarantee that those other workers will never come into contact with the employees working on or in connection with the contract, then you would not have to cover them. But that's, for lots of folks, going to be a pretty difficult thing to prove, because you have to show that people are not likely to bump into each other in parking lots, in bathrooms, in hallways, in stairwells, and in break rooms. And so we're finding that most employers are having to apply the mandate to the entire work site if they have other covered employees there. One other thing I'll just flag is we've been asked about remote workers. If a remote worker in the US is working out of their home, but they are working on the covered contract, they are still covered even though they are remote. If we can go to the next slide, this next slide talks about when you may see this requirement folded into a covered contract. And that in turn drives when you as a contractor or a subcontractor are expected to be in compliance. So the executive order and guidance collectively provide that the mandate is supposed to be included in any new contract that is issued on or after November 14th. Or for solicitations for new contracts that were put out on or after October 15th, then the mandate is supposed to be included in the contract. For other existing contracts that predate those two dates, the mandate is supposed to be incorporated when the contract is either renewed or extended, or if there's an option in the contract, when that option is exercised. The guidance document, interestingly, also encourages federal agencies to try to include the mandate in non-covered contracts. So you may see that you are getting requests to fold the mandate into a contract, and you're really going to want to do your due diligence around whether that's a covered contract or not, because you may have more ability to push back if that's something that you want to do if you've got a non-covered contract. The guidance says that the effective date is December 8th. That's only going to work for situations where you already have a covered contract and you have enough time before December 8th to get your covered employees fully vaccinated. And obviously 2-dose vaccines, it takes a while to complete the vaccination round. If you hit that December 8th date and you have not been covered, then after that, the effective date is the first day of the performance period for the covered contract. One thing I do want to mention that's relatively recent news is that the White House did put out a statement just this week indicating a little bit of flex on these deadlines. And the FAQs on that federal task force site have also been updated. And generally what they've been updated to provide is that employers have some discretion around enforcement of the mandate and what they would do with a non-compliant employee who's not been granted an accommodation. And I'll talk a bit more in a few minutes about accommodations. The new FAQs talk about the fact that the employer has some discretion to use its regular progressive discipline processes to try to enforce its mandate. And that may mean allowing an employee to go unvaccinated a little bit beyond these deadlines that I've mentioned while you engage in progressive discipline, though ultimately you will be expected, to try to bring people into compliance. The other thing the White House said is that we can expect federal agencies to follow their usual enforcement approach, which is, they've got some heavy hammers out there that they can use, but typically they would start with education and efforts to get voluntary compliance. So you should obviously do your best to be in compliance, but we did just hear that there may be a little bit more flex. If we can go to the next slide, the other thing that you should be aware of with the federal contractor mandate is that other than a situation where you might offer routine weekly COVID testing as an alternative to the vaccine for an accommodation reason, you are not allowed as a matter of course to offer employees a routine testing alternative. This mandate is truly a vaccine mandate where testing would only be permissible as an alternative in these narrow situations where you may be granting disability or religious accommodations. You also are not allowed to accept antibody tests. We have heard of some employees who've had COVID wanting to be exempt from vaccine mandates because they believe they can provide medical proof that they still had antibodies. That is not going to be acceptable for federal contractors. There's also a few non-employment requirements. There are requirements for unvaccinated visitors to a covered contractor site to be masked and to engage in social distancing. And you do have to designate a person, a point person, to coordinate your COVID safety efforts at covered workplaces. With that, I'm going to move to briefly talking about the OSHA ETS. So if we can move to the next slide. That ETS is going to apply to private employers with 100 or more employees. As I mentioned earlier, we're expecting that ETS to get published any day now. I will tell you what we know, which is relatively limited as to the ETS, and then I'll flag a couple of open questions that we're all going to be quickly looking at when we see the ETS released. The OSHA rule is going to require all private employers with 100 or more employees to either mandate vaccines and offer a routine weekly COVID testing option for individuals who do not want to get vaccinated. And again, this is a little bit broader than the contractor mandate because that can be offered as a matter of course, even outside of the accommodation context. We also know that the rule is going to require covered employers to provide paid time off for workers to get vaccinated and to recover from vaccine side effects. There's lots that is unknown, and some of those issues are we don't know what the effective date of the ETS will be. We don't know how much time you'll have to get into compliance. We also don't know for sure how the 100 employee threshold will be counted. I am guessing there will be some, joint employment counting requirements like we often see under other employment laws, but we're still waiting for that information. And there are open questions around pay obligations. I think lots of us employment lawyers have assumed that the ETS will probably require employers to pay for the COVID test since it's a mandated business expense, and likely would require payment for the work time to go get tested, sort of akin to when a non-exempt employee is told, for example, that, we know you don't work on a Saturday, but we're going to mandate you coming in for this training. You would normally have to pay people for that. So a lot of us have believed there will likely be pay obligations, but I did see a report just yesterday from Bloomberg that there are some sources saying that the ETS actually has been drafted to allow employers to pass on at least the test cost to individuals who choose not to get vaccinated and are not eligible for a religious or disability accommodation. So we'll obviously be looking at the ETS really carefully to see if that's in fact the case. it may be that that information's not correct, and we aren't sure what the ETS is going to say about the time spent to get vaccinated, or excuse me, to get tested. If we can move to the next slide, the last category of covered employees that I mentioned are healthcare workers who are working for a participating Medicare, Medicaid funded healthcare entity. We have not seen the proposed rule yet. It is going to be issued by the Centers for Medicare and Medicaid Services. We had thought it would be issued in October, but we have not seen that yet. So we have to stay tuned for more information on that. This mandate will be an expansion of a rule that has been proposed for nursing home employees. And as you can see from the slide, is going to cover a much broader group of employees. If we can go to the next slide, one other update I want to flag for you for healthcare workers is that effective June 21st, many healthcare entities were already subject to an OSHA ETS. That ETS did not mandate vaccinations, but it did mandate paid time off to allow people to get vaccinated. And it mandated a number of other key requirements. I won't run through all of them, but it's things like having a COVID plan for each work site and doing a work site specific risk assessment and doing patient and employee health screening and providing PPE for healthcare workers, et cetera. So there are really helpful materials on the OSHA website. If you're a healthcare entity and this is news to you and you haven't gone in to figure out if you're covered, I would encourage you to do that. I'm going to move on to the next slide and touch base on a topic that we know many of you are having to, you're already dealing with it or you're anticipating dealing with it as you prepare to comply with any vaccine mandate that may impact your organization. And that is the issue of disability and medical accommodations. As you probably are aware, under federal law and many state and local laws, employers have to grant reasonable accommodations for conditions that are qualifying as a legal disability or for sincerely held religious beliefs. And that is going to be true with respect to these federal vaccine mandates that I've mentioned. And the federal contractor task force guidance that I mentioned expressly acknowledges the accommodation obligation that employers are going to have. Those are, we definitely are seeing them come up both in the medical context and the religious context. I think we are, at least my experience is that my clients are dealing with fewer requests for exemptions based on disability or medical conditions, because often when somebody is immunocompromised, their providers actually want them to get vaccinated. But we do sometimes see exemption requests. We're seeing many more exemption requests around sincerely held religious beliefs, and that is proving to be more challenging for employers because we're seeing, unfortunately, we're seeing more folks potentially trying to abuse the system and online providers who are offering, kind of fake religious belief notes, et cetera. And so I'll talk a little bit more about what we can share with you about how far you can dig into vetting those issues. But obviously that's going to be something that can be challenging for employers to deal with. Couple of things I will flag for you. The federal contractor task force guidance says that covered contractors have to make exemptions for sincerely held religious beliefs, but also for medical conditions. So the guidance requires accommodations beyond conditions that might just be a disability under the law. And actually any medical condition that is incompatible with somebody getting a vaccine has to be accommodated for in the federal contractor context. So that's something to be aware of. For medical accommodation requests, you are allowed to ask an applicant or employee for supporting medical provider documentation to actually verify that there is truly a condition that justifies an exemption. And then as an employer, you're required to engage in the same interactive process that you're used to doing to assess reasonable accommodation versus undue hardship in other contexts. If we can move to the next slide, I mentioned that religious accommodations are proving to be a little bit more challenging. You are not allowed in the religious context to ask for something akin to medical provider documentation. So you are not allowed to tell people that they need to give you, for example, a note from their the head religious official of the religion to which they belong, for example. You can do some vetting, and what you're allowed to do is ask the employee questions, about what religion they belong to and about the sincerely held religious belief, to do some testing of whether there is in fact a religious belief and it is sincerely held. The EEOC has lots of materials on its website that can help you sort through that process. There's a guidance document around religious accommodations as well as disability accommodations, and there's an FAQ section around COVID that I believe was recently updated on the religious accommodation front. But you want to be mindful that the law takes a really broad view of what constitutes a religion and what constitutes a sincerely held religious belief. And the EEOC guidance provides that even if that belief is not one that is commonly held within the particular religion, that doesn't necessarily mean it is not a valid religious belief that you have to accommodate. We've heard some interesting approaches around vetting religious accommodation requests. NPR ran an article recently that talked about an employer that was, at least in the context where an objection was based on the belief that some of the COVID vaccines were developed through the use of aborted fetus tissue. The article said that some employers are requiring employees objecting on that basis to fill out an affidavit of sorts, affirming that they don't get other vaccines or take other medications that might contain that same aborted fetus kind of backdrop to the development of the medicine. We don't know for sure how courts are going to react to those approaches, and so it may be something that is available to you, but I'd encourage you to talk with your regular lawyer at Lathrop GPM, so that if you are doing some more aggressive vetting, that you're comfortable with your particular approach. I think I may have flipped forward one slide too many, so I'm going to ask Jessica to slide back to the prior slide just for a moment. So I wanted to mention a couple of additional things about accommodations. Deciding whether you can grant a reasonable accommodation, what type of accommodation you might grant, and whether you have a good undue hardship argument is, as you probably know from dealing with accommodation issues in other contexts, that's going to be a very individualized and fact-specific analysis. A couple things that I want to remind you of is that the law does not require you to grant a first choice accommodation if there's a reasonable, effective alternative. And you do not have to grant an accommodation that is an undue hardship, but undue hardship is a pretty stringent burden. So if you're going to deny an accommodation, and particularly if you're thinking you may fire someone, I'd really encourage you again to talk with your lawyer within our group about that. Some of the common types of accommodations that we're seeing are the routine weekly COVID testing, having people work remotely, potentially temporarily assigning them to different duties, and in some cases, a leave of absence. If we can go to the next slide, I just want to flag that there have been some challenges to some employers who have been in the news. If we can move forward one additional slide. There have been some challenges to employers that have taken the position of putting people on unpaid leave as a form of accommodations, with I think the United Airlines approach being kind of the most high profile one, because that one is being litigated. There's a federal Texas court ruling where they temporarily have enjoined United Airlines from pursuing that approach under the view that it is not reasonable. And so again, I would encourage you to be talking with us about your different approaches. I'm going to move forward to the next slide. These next slides are really in the materials to be more of a resource document for you. I'm not going to talk about them in great detail, but I did want to mention that we've seen a number of court challenges already around the federal mandates. I also want to just flag that to date, most of the court challenges have not been successful. And so I don't think employers should just be assuming that these federal mandates are going to be struck down. It's not impossible that they might be, or that aspects might be. But at least to date, we've not seen a lot of success on those challenges. If we can move forward to the slide that starts with employment law under the Biden administration. I'm going to wrap up by just flagging a couple of additional things that are that we're seeing in terms of shifts in the federal employment law arena since President Biden took over the White House in January. And I'm going to be pretty high level, so I can turn things over to Rosie to continue the update. The Trump administration had loosened a few standards around the classifications of workers and some wage and hour enforcement standards under federal law. And we've seen the Biden administration roll most of that back. And so, for example, under President Trump, the U.S. Department of Labor had started a process of trying to change the rule that gets used to determine if a worker is a contractor or an employee. And under Biden, we've seen that rule rescinded, and we are back to the Obama era rule, under which we saw a lot of enforcement and focus on misclassification of workers. We also are seeing some traction around a higher minimum wage. If you're a federal government contractor, you should be aware that President Biden issued an executive order that will be effective in July, was effective in July, requiring a $15 minimum wage for federal contractors. And he generally favors a higher minimum wage, so it may be that we see more proposed legislation in that area for employers at large. We also are seeing some traction around a possible elimination of the FLSA tip credit for tipped workers. And so that's something to stay attuned to if you have tipped workers. If we can go to the next slide, keeping in the same vein of tougher wage and hour laws, the Department of Labor recently increased the fine that can get charged when an employer unlawfully keeps employees' tips. And we're hearing some talk of potential increases in other types of penalties that can be awarded for wage and hour violations. Two other things to keep an eye out for. President Biden is a proponent of paid family leave. You probably saw that there was efforts very recently to try to get paid family leave enacted that failed, but that may be something that we see resurface. And we also expect that we may see some proposed legislation around LGBTQ equity rights in various areas of federal law, including employment, housing, education, et cetera. And Rosie will touch a little bit more on that issue in light of a Supreme Court ruling last year. So with that, I am going to wrap up. Thank you so much for your time. I'll be at one of the COVID tables later if you have questions, and I'm going to turn it over to Rosie.
Thank you, Megan. Megan's done a great job of providing you with summaries on the legal developments concerning COVID and beyond. And the only item I'd like to add, because some of you have asked, is for non-federal contractor employers, for those private employers with 100 or more employees, what is the authority? Well, the OSH Act, the Occupational Safety and Health Act, allows for an ETS, an emergency temporary standard, in response to, quote, grave danger. And while Colonel Jessup from A Few Good Men may not think there's any kind of danger other than grave danger, apparently OSHA does. I'm sorry, I always have to work in a quote from my favorite legal movies of all time. So this new ETS, as Megan said, is expected to issue very soon, probably this week. So for those private employers in our audience with 100 or more employees, stay tuned and stay in touch. Now, I'd like to start with some practical tips based on evidence we wish we had or didn't have in litigation, investigations, depositions, negotiations, charge responses, mediations, and so on. And I don't think we've covered this topic per se before, but as you know, we're not here today to provide legal advice. This is not the point, but the purpose here is to give you some tips that you might consider as you are enacting some of the requirements of the various laws that we're discussing today. So first, we wish we had, and will wish as things develop, that we had current updated COVID policies with each of you and accommodation forms as needed that comply with the legal requirements. We wish and will wish that we had documentation of engaging in the interactive process for disability or medical, as Megan said earlier, or for religious requests for accommodation as needed. We wish we had consistent application of policies to those who are similarly situated, what we call comparator evidence or comparable employees. We will wish we had truly and timely, empathetic and compassionate and fair responses to employee complaints. And you note that the word fair is in quotes. That's not required by the law. Fairness is not required, but we can guarantee you that fact finders, judges, juries, mediators, arbitrators are going to want to see some story that connotes and demonstrates fairness. We've also got the word reports here in quotes because it doesn't have to be an employee complaint about harassment or discrimination. They don't have to use the word. There are no magic words they have to use, like I'm complaining. It could be a report that something is going on that is a violation of a policy or an ethical violation or a harassment situation or a discrimination issue. We wish we had updated policies, whether your policies are all in one employee manual or whether they are individual policies posted on your intranet that regularly take into consideration updates and legal developments, and including a soft skill approach that also takes into consideration societal expectations, for example, Me Too harassment and Black Lives Matter. We will wish we had anti-harassment policies that take into consideration variances in state and local laws. And for some states and localities, that can be as simple as, not all, but for some, it can be as simple as, and other protected classes as protected by applicable laws. And we'll wish we had good standards of conduct with catch-alls. What do I mean by catch-alls? When you're going through your list of items for your employees that could lead to discipline, whether it's counseling or harsher disciplinary action, including termination, we will wish we had evidence that you had a catch-all as simple as something along the lines of, and any other activity, conduct, or omission which, in the opinion and judgment of management, is not in the best interest of the company or the employer. So if you could, thank you. Document the conduct, not the condition. Example, what's relevant and appropriate to document is not the condition of attention deficit. It's not the condition of alcoholism or any other addiction, but the conduct and performance related issues is what's relevant and what is going to win in a claim at any level, whether it's a charge response or all the way through and including arbitration or a trial. Reports that convey facts, just the facts. Think like a police officer. And these are important points. Many of you in the audience know these things intuitively, but it's important to train our managers on them as well. Training our managers and our supervisors to write reports in a way that convey facts, not conclusory terms and not supposition. And of course, facts can be observations. For example, they can include things like tone of voice, volume of voice, facial expressions, body language, but it's important to convey facts, not conclusions in the documentation. It's also very helpful to us when we have signed documentation, and I'm going to approach that in two different ways here. One is signed documentation by the individual employee who is being disciplined. at a minimum, their signature. And I've had this discussion with many of you in the past. If they refuse to sign, why not just handwrite that in there? I wouldn't necessarily type it in there and have them make it easy for them to refuse to sign, but why not handwrite it in there or let them handwrite it in there? Employee refused to sign and then have them sign that. The point is that when we get into a deposition, when we get into trial or arbitration, we now have clear evidence that the employee was made aware of the counseling and had an opportunity to correct it. This can even help you in an unemployment compensation setting. Have a good performance management story to tell. Fact finders, whether it's judges, juries, mediators, they love to hear a good story that really conveys all of your efforts along the way. We wish we had evidence that sometimes at least you've considered a last chance agreement that conveys opportunity, not challenges, but opportunities, how the employee can improve. We wish we had evidence that shows the accommodation or accommodations that have actually been requested by the employee for disability/medical or religious reasons. And of course, there's always due diligence considerations in M&A deals and combinations and that sort of activity. Slide. So here is some evidence that we wish we didn't have. Of course, the converse of everything that I've just mentioned on the earlier slides. Also, inappropriate or snide texts. Everybody's been, just as written memos years ago, everybody's gotten used to writing more professional emails. But what about texts? What about chat messages? What about Slack messages? All of those can create some really harmful evidence that we wish we didn't have. Documents that relay information on protected classes where it has no business in the documentation. And again, this is an excellent training point for your managers and supervisors. There's no need in most any case to be documenting anything about a person's protected class, including FMLA leave, including protected status, including what they raised an issue about or what they complained about. That could be in a separate file. We wish we didn't have evidence of inconsistent treatment of similarly situated employees without a reasonable explanation for that different treatment that you can provide when you raise your right hand and take the witness stand. One other item I would add to this slide, evidence that to the prior slide on evidence we wish we had, and I'll come back to this in a minute. Timely response in Missouri and Kansas to service letter requests. Typically, an employee has a year to send a request for a service letter, and if you don't know what this is, be in touch after they've been terminated or even if they have been resigned, and the employer must respond to that. And we've seen an uptick in service letter cases recently, and in fact tried one last year. So important to keep that in mind too. All right, if we could advance. Thank you. So I wanted to switch gears and cover this Whole Foods Black Lives Matter case for you. This case resulted in a 2021 decision from the District of Massachusetts and is currently on appeal in the First Circuit. So again, stay tuned. Employees worked at Whole Foods stores across the U.S. and they brought a class action in 2020 against Whole Foods and against Amazon, the corporate parent for Whole Foods, because Amazon, as you may have noticed if you frequent or if you ever go into a Whole Foods store, Amazon employs Prime shoppers, and those are the shoppers who fill online orders through your Prime account, and they run around and sometimes, are picking things off the shelves as requested by their customer and putting them in bags that then they deliver to people's homes. So the plaintiffs sued Amazon as well as Whole Foods because this impacted also some Prime shoppers. Well, in the wake of the George Floyd killing and nationwide protests, people all over were showing support for the BLM movement. And even though Whole Foods' public support was for the BLM movement, it began disciplining plaintiffs and other employees for wearing BLM masks and other items like pins. Well, one employee was sent home and terminated due to accumulation of points for lack of attendance. Other employees were just disciplined. And this Whole Foods case actually cites Bostock, the 2020 U.S. Supreme Court case that we'll discuss developments from in just a minute. And the court said the proper focus is on the protected characteristics of the person bringing the claim. And since no plaintiffs here have alleged discrimination based on their race, nor that they were discriminated against for advocating on behalf of a coworker who was subject to discrimination, the plaintiffs failed to state a claim and the case was dismissed. As I said, it is before the U.S. Supreme Court, before the First Circuit now, so stay tuned. One other item I wanted to cover before we move on is that the Whole Foods had a dress code policy that prohibited employees from wearing apparel at work with visible slogans, messages, logos, or advertising. And there was evidence introduced by the plaintiffs that they had allowed certain types of logos or slogans, but that did not change the judge's opinion in this case, and we'll see what the First Circuit does with it. Slide. So on the Bostock, he pronounces the lead plaintiff pronounces his last name Bostock. You've probably heard it pronounced Bostock as well, which is possibly the more common pronunciation. So I wanted to cover where the EEOC currently stands with SOGI, sexual orientation and gender identity. Megan presented on the Bostock case at our annual State of Litigation conference. And there were 3 companion cases, Bostock, Zarda, and Stevens. Each was fired by different employees after their employer learned about their sexual orientation or plans for their gender identity transition. And the court, the U.S. Supreme Court, in June 2022, focused on the plain language of Title VII. Discrimination based on sexual orientation or transgender status necessarily entails discrimination based on sex. They used a but-for test. And that case was written by, the lead justice was Justice Neil Gorsuch, who was nominated by President Trump from here near us in the 10th Circuit, which includes Kansas and Colorado, of course. So by a relatively conservative judge who is seen as a constitutionalist, along with, following in the footsteps somewhat of Justice Scalia. So terminating or disadvantaging an employee because they're married to someone of the same sex, but an employer would not do the same to an employee married to a member of the opposite sex. The court said it's because of sex. And similarly, if an employer terminates an employee because that person was identified as one sex at birth, but identifies as the other sex later, then that would be considered taking action against an individual because of sex. What do we mean by disadvantaging? Same thing as we mean in other contexts in employment law, which could be anything from hiring, firing, pay, job assignments, promotions, discipline, benefits, training, and any other term or condition of employment. Same analysis applies with respect to a hostile work environment or harassment based on these grounds. And of course, I wouldn't go on without mentioning that the EEOC recognizes that employers, quote, employers are not allowed to discriminate against job applicants or employees because they are straight or cisgender, meaning their gender identity corresponds with the sex at birth. So that would be reverse discrimination and not allowed either. The open issues here include sex segregated accommodations such as restrooms, locker rooms, dressing rooms, and showers. And the EEOC takes the position that employers cannot deny an employee equal access to a bathroom, locker room, etc., that corresponds to the employee's gender identity. And now OSHA has said that employers should allow employees to access whatever restroom is consistent with their gender identity. Dress codes is also an open issue. Traditionally, the courts and the EEOC have said that an employer can impose a dress code as long as it is not discriminatory and is reasonable and does not place a greater burden on one gender over the other. Well, in Bostock, the Supreme Court declined to take up the issue of gender dress code, but we can make some predictions between the rationale in Bostock and the Price Waterhouse at the time versus Hopkins case way back from 1970, in which the Supreme Court of the United States found that Title VII prohibits discrimination based on gender stereotyping. For example, stereotypes that women should dress or look feminine, or that men should act masculine. And the final thing that, at least so far, we know is an open issue under Bostock is the scope of the religious exemption. The Supreme Court did note that its decision did not address various religious liberty issues, including the First Amendment and exemptions that Title VII provides for religious employers. Slide. I would like to wrap up by talking about developments in 3 states, and the first one is brand new, and that is effective August 28, 2021. So if you don't already have your posters up, if you have Missouri employees at all, you want to have these postings up, and there's one available on the Department of Labor Missouri website. It's just one page. It looks like this. And so that site is labor.mo.gov. You can get that one-page poster, but it provides that for domestic abuse leave, that Missouri employers with at least 20 employees must provide unpaid leave. Of course, if it's covered leave by FMLA or some other paid leave, then that would be different. Otherwise, under VESA, it does not need to be paid leave. For any employees who are victims of domestic or sexual violence, or who have family or household members who are victims of such violence, in order to do certain things, including seeking medical attention, take court action, participate in safety planning, obtain services from a physician, etc. Next slide, please. There are more details in your materials, and I won't belabor this, but for those with employees in Missouri, you will want to get the posting up and be aware of this. And if you could go to the last slide on VESA, next slide. At the end here, I point out there's no penalty per se for failure to comply with the notice requirement, but compliance is simple as the notice can be sent electronically. But what we all have learned is that, fact finders want to see compliance with the law. And even though there's no penalty, you don't want it to come back to haunt you by someone arguing, well, judge, jury, arbitrator, they didn't follow the law by posting this and advising of our rights under VESA. So therefore, you should believe they didn't follow the law because they retaliated against me because I took protected leave to which I was entitled. So that inference kind of statement, you don't want coming back to haunt. Next slide. Kansas has long had a similar law that an employer may not discharge, discriminate, or retaliate against an employee who is the victim of domestic violence or sexual assault for taking off time from work to do certain things related to that. And next slide. Minnesota has no domestic sexual violence protection law at present, but they do have something that covers much of this, and that is the Crime Victim job protection laws. So for those of you with any employees in Minnesota, you want to be aware of that. It allows the victim or witness who is subpoenaed or requested by a prosecutor to attend court to testify, and the employer is required to allow a victim of a violent crime and a victim's spouse or immediate family members reasonable time off from work to attend criminal proceedings related to the victim's case. Last slide. And Megan told you about this earlier, but here it is again. The EEOC has released its own internal religious accommodation form that we think you may want to be aware of, because it may help some of you struggling with, and that's why the EEOC released it. They knew that people were struggling with religious accommodation issues and how to deal with it. And somebody posted that Minnesota also has ESS time for victims. Thank you very much for that. Slide, please. Now I'd like to turn it over to Mark Matheson, who will provide you with a labor law update.
Well, thank you, Rosie. Quick trip through the traditional labor law developments and updates now. I suppose maybe I'm not the first person to point out that we're living through a time of unprecedented challenge and change. The National Labor Relations Board, which enforces the federal labor law, the NLRB, today reflects those things about our times. The new administration in Washington, President Biden's administration, has taken a very strong position in favor of union advocacy and collective bargaining generally. And we've seen throughout 2021 appointments that result in many new faces taking up critical positions with the NLRB. There is a new democratically appointed majority on the labor board. And so that points to a lot of shifts, potential shifts in the law. Lauren McFerrin has been appointed as chair. She's a strong union advocate. Gwen Wilcox and David Prudy are now members of the labor board appointed by President Biden, and both of them have worked for unions and have strong union backgrounds and leanings. Jennifer Abruzzo is the new general counsel for the NLRB. She's a longtime labor board servant with a strong dedication to collective bargaining in general and an expansive interpretation of the National Labor Relations Act, the federal labor law. So we are expecting major shifts that affect both union and non-union employers in respect to interpretations of the law and what the law requires of employers, and also with respect to prosecutorial or enforcement approaches that the general counsel and the labor board will be taking in the future. So Jess, what have we seen in 2021? Actions by the board in 2021 have been relatively limited because the board has been awaiting these appointments, and the democratically appointed majority was not secured until late August or early September. But there have been a few things that have happened that actually have changed the law. Generally, the board has to wait for a certain case to present itself at the board in order to rule or overrule previous case law. But some of the things that have happened this year, we've seen the withdrawal of a proposed rule that was from the Trump board, the rule stating that students are not employees under the Labor Act. And this withdrawal foreshadows later memo by the general counsel, where she clearly takes the position that college athletes are employees with protections under the National Labor Relations Act. We've seen the rescission of many other Trump board memos or guidance, including some that involve union dues, the dues checkoff that employers are required to do, and when they are no longer maybe required to do that. What is the standard for a union's duty of fair representation? And also withdrawal of guidance by the Trump General Counsel on application of the reasonable rules standard regarding employment policies and rules. We've seen case law where the labor board actually has now approved the use by unions of inflatable Scabby the Rat as a protest or union organizing tool. This is where this giant inflatable rat will be hauled out at a protest in front of a non-union employer's building by striking employees. Also approval of bannering, where for neutral in front of neutral employer sites, non-union employers who may be neutral on a construction site, for example, the union will come with these large banners that say, "Shame on you, employer, you haven't signed a collective bargaining agreement," and that sort of thing. And these have been union organizing tactics for a long time, and they've long been controversial. This year, the labor board, before the democratically appointed majority took hold, approved those and said they are not unfair labor practices, and they in fact constitute protected concerted activity under the Act. Also this year, the board upheld the traditional contract bar, which protects unions from being decertified or from challenges by other unions during the term of a collective bargaining agreement. There have been several cases ruling on what is a reasonable rule using the Trump board standard, which is much more employer favorable. And then cases dealing with the conflict between the National Labor Relations Act and Title VII as far as what is and isn't harassment that may be protected or, on the other hand, prohibited. Those case law positions in particular are all just for now, because we expect to see a lot of cases coming before the board where the board decides to overrule prior board precedent. Next, Jess, we've seen the General Counsel has laid out an enforcement agenda. The General Counsel is essentially the prosecutor for the labor board and directs all the litigation activity of the National Labor Relations Board and its regions. This enforcement memos that have been released include two memos actually, encouraging the regional directors to seek full relief in their advocacy to the labor board in cases, and also what full relief would mean in the context of regional directors entering into settlement agreements for unfair labor practice charges. This full relief this really flies in the face of the historical fact that the remedies available under the federal labor law are weak, have traditionally been considered weak. They don't feel that way to the employers that I've worked with, but overall, and the biggest example is that the General Counsel is now directing the regions to seek consequential damages, which might include things like for a fired employee, one who was fired in violation of the protections of the labor law, interest that they had to pay on credit card fees because they didn't have a job anymore, they weren't getting a paycheck, or penalties on early withdrawals from retirement funds, or the loss of a home or a car because of late payments by the employee who didn't any longer have a paycheck. Consequential damages, the General Counsel says, might also include the cost of replacement health insurance, or letters of apology, or sponsorship of a work authorization, or limitations on the non-admission clause in a settlement agreement, or even disallowing such a clause altogether. So this idea of seeking full relief is a significant positional change that we will need to be watching for, and employers will need to be aware of going forward. Then, not long after that memo, the general counsel released a memo, as I had noted before, taking the position that college athletes are employees under the Act, under the federal labor law. And in addition, noting that there's an existing board case that says other students also are protected employees under the Act. That's a Columbia University case from 2016. And these memos or these positions together have very wide-ranging and important implications for higher education institutions, and the enforcement of these is expected to be a major initiative of the general counsel and likely of the labor board as we go forward. The memo about college athletes also notes that there may be joint employer applications as between the institution and, for example, the NCAA or the conference in which the school participates. And joint employer issues also are expected to be a major initiative or enforcement tool that this general counsel uses. The general counsel has also emphasized the importance of injunctions to stop unfair labor practices while a case is being litigated, or to timely protect employees' Section 7 rights. And we, as I noted, we're likely to see changes to the joint employer rule. There was a Trump board rule that held potential control over employees was not enough to make an entity a joint employer, but that is not the position of this new board. That rule has been is still in place, but we expect it won't be in place for very long. The next slide. Continuing on the enforcement agenda that has been adopted by the general counsel, handbook rules are a major focus. We expect to see a return to very close scrutiny of employer policies and rules in employer handbooks that maybe limit the ability of an employee to speak to the media, confidentiality issues, how to be, requiring an employee to be respectful in the workplace, and much more. Also, we anticipate a return to independent contractor misclassification cases. We expect this board to take a return to the position that misclassifying a worker as an independent contractor instead of an employee is itself an unfair labor practice. And that actually is something that in the college athlete memo, the general counsel takes the position that calling these college athletes student athletes is itself an unfair labor practice, because it leads them to believe they don't have rights as employees. We are looking for changes potentially to the religious exemption standard for institutions, as far as when the labor board can exercise jurisdiction over them. And changes are afoot with regard to confidentiality issues related to investigative interviews, when confidentiality instructions to witnesses in investigations and arbitrations may or may not be permitted, or when they may constitute unfair labor practice. Same with grievance investigations and confidentiality provisions in settlements. We're looking for changes to all of those things. And Finally, a few of the other issues that the general counsel is looking to change or to consider carefully. Issues about union access to the workplace. Generally, employees have greater access than outsiders do, and a union is generally an outsider particularly when they're not a recognized union in the workplace. So for organizing purposes, we're looking for more open access. The general counsel is likely to look for a case or ways to expand the access that unions have in an organizing context to the workplace. There will be movement on dues checkoff, as I mentioned, and on an employer's duties to recognize an existing union when they buy a company in a merger acquisition setting. And then this one will sound familiar to some of you who may have been coming to our seminars for years. Weingarten rights, that is the right of an employee to have a witness present whenever the employer is conducting an investigation that might lead to discipline. There's been a back and forth over the last 15 years at the labor board about whether those rights apply in non-union settings. Currently, they do not. We expect that to change back, and that there will be a new ruling as soon as the board gets the opportunity to say that these Weingarten rights to a witness in an investigation setting applies equally to union and non-union employees. Okay, Jess. So some of this at the labor board is affected by cultural shifts and the changes and challenges that we see at large. And employers, though, in addition, just need to be aware of how cultural shifts may be changing attitudes about unions. There's been a tremendous increase in strike activity this year. There was this large strike, or is this large strike at John Deere. The Hollywood ITSE union had come close. I mean, or maybe they went on strike a short time. I don't remember, but they finally signed a contract, but it's not ratified yet. And the news is that it might not be ratified by the members. So that remains to be seen. There was an organizing activity at Amazon in Alabama this summer that was defeated, but there's ongoing Amazon organizing activity in New York at this time. And also Starbucks, there are going to be elections for unions at 3 separate Starbucks locations in New York coming up in the next month or so. And so generally, we're seeing greater interest maybe in worker rights and people rethinking their position on unions. And certainly the labor board is going to be more receptive to expanding the protections available to various workers across industries and settings. Adjuncts and other faculty organizing increases can be expected, and students and student athletes or college athletes, we can expect to see organizing now in those sectors as well. So, is that my last slide? So yeah, this is my last slide. The notes that I have for you is to just be prepared. I mean, as an employer, whether you're a union or a non-union employer, you need to think about how to prepare for some of these changes. There will be major changes at the labor board, and potentially driven by and in the culture at large. What are your plans with respect to if there is union organizing in your workplace? Have you taken a position? Have you decided who and how will you communicate to workers if there is interest or an election to be held for union organizing? You might be thinking about a handbook rules review at this point in time. we can expect much greater sensitivity on the part of the labor board to the possibility that various types of handbook rules constitute unfair labor practice. One key, and this is similar to what Megan and Rosie had mentioned as well, training your managers. It may be that either during the last 4 or 5 years, you backed off some of that training, or maybe you haven't done it in the past, but managers need to have a basic familiarity with the protections that employees enjoy under the Labor Act and what managers can and can't do and say in various kinds of contexts. You also might be beginning to analyze the possibility that you are a joint employer with another entity. That might be a temporary agency, that might be another institution or that you are associated with in the franchise context. That has been a major controversial issue between, well, at the labor board and elsewhere as to franchisors and franchisees. So it might be time to look at where things stand with respect to joint employer analysis, if, as expected, we see some form of a return to the previous joint employer standards prior to the Trump administration, where it was enough to become a joint employer for you to have the potential to control the terms and conditions in the workplace, even if you didn't actually exercise that. And so with that, we're going to move along, and we'll hear from Bridget Romero, my partner, on a couple of specialized topics, immigration and employee benefits. Bridget, in addition to advising clients on typical resources and employment law topics, is one of our immigration specialists, and she's going to particularly share a few updates today in that area. Take it away.
Thank you, Mark, and good to be with everyone this afternoon. We're going to do a quick fire immigration update, 3 quick updates, and then 1 reminder on an employee benefits topic. So immigration update number 1, effective November 8th, what were known as these 4 regional travel restrictions, meaning there were certain regions of the globe where travel was heavily restricted due to COVID. Those are going to be lifted and replaced with a global requirement that all foreign national travelers coming to our country provide proof of full vaccination and proof of a negative COVID test within 3 days of their flight. Now, United States citizens and legal permanent residents who are abroad but who are unvaccinated won't be prohibited from returning to their own country, but they will need to have a negative test within 1 day of their flight. Relatedly, the borders with Mexico and Canada have been really restricted to essential travel. And also here in November, that will change. So land and ferry ports of entry will resume for vaccinated only, non-essential travelers. So this is an important update, perhaps both for you personally, but also for your workforce who may need to travel internationally and/or any foreign national travelers who you need to come to the country for work purposes. Immigration update number 2 is on our next slide, and it relates to a topic that you're all probably very aware of by now, which is the flexibility afforded for the filling out of the employment eligibility verification form, known as the Form I-9. You can see here on the slide, pre-COVID world was a very antiquated and arcane relic of federal law. There are many of those, including lots of things in the FLSA, but certainly needing to physically inspect identity and work authorization documents is one that drives employers crazy, especially as we become more and more remote and have employees in the field. Thankfully, the Department of Homeland Security did provide relief for this back in March of 2020. And so since then, you've been able to do remote inspection of the documents. Recall the standard for this is that the documents reasonably appear to relate to the person standing before you and appear to be genuine. You don't have to be a sleuth on detecting fraudulent documents. So the guidance on this has evolved since March of 2020. It used to be actually pretty ridiculous, where if you had any employees working in the office, you couldn't do this. And that has since evolved. And so if we go to the next slide, we'll see what the current standard is, which became effective in April of this year. Physical inspection is only required presently for those employees who physically report to work on a regular, consistent, or predictable basis. And for those who don't fall into that category, you can continue to do virtual inspection of documents, you know, through a video link, through fax, email, etc. There is some precise technicalities that you need to comply with on your Form I-9s, which you're probably used to by now, but for those of you that this may be a new topic, you need to note in Section 2, COVID-19 is the reason for a delay on the actual physical inspection. And then once people do return on a regular, consistent, or predictable basis, you can go ahead and do the physical document examination. They need to come in and see you within 3 days of resuming those in-person duties. Now, as with everything COVID, you know, we get extensions, things get moved and changed. This current guidance on I-9 flexibility is set to expire December 31st of this year. So we'll see if they do another extension or if it truly does end at that point in time. Our next immigration update number 3, has to do with higher education. So for those of you that are here today from various colleges and universities, you may have returning students who are wondering how they're going to get back and things of that nature. The State Department is allowing for visa interviews to be waived, and there's usually a requirement for an in-person visa interview for our F and J students, which are the most common categories that apply to foreign national students. If it's someone who's had a visa before, the in-person interview requirement can be waived, or if it's somebody who comes from a visa waiver program country, but they're a first-time visa applicant, could also be waived as long as there's no obvious signs of ineligibility on their application. There's about 40 countries that participate in the visa waiver program. Some of them you might expect. Ireland, United Kingdom, Spain, a lot of the European nations. Places like China are not on that list. So that was immigration update number 3. Now for a very quick update or reminder, if you will, on an employee benefits topic. One of the various relief packages that came about during this last 18 months had to do with cafeteria and flexible spending account plans. And so, you know, normally those elections have to be made at the end of a year for the new year taking effect, the benefit plan year, and you can't make any changes. Also with amounts in flexible spending accounts and cafeteria accounts, you know, it's use it or lose it. So there was relief provided on both of those fronts. In large part, the thinking was there needed to be delay on elective surgeries, elective procedures, for example, that you might use your FSA monies for due to COVID, patients taking up hospitals and providers not being able to provide those elective services. So employers were allowed but not required to provide relief to their employees along these lines and to allow for carryover, allow for changes in elections and contribution amounts. In order to make sure that that is all wrapped up the way it should be, you do need to do a formal plan amendment, however. And so for elections and changes made for a 2020 plan, for example, you need to make sure you've done a plan amendment, a formal plan amendment by the end of this year. So work with your brokers on that if applicable, and let us know if you have any questions, but you'll just need to make sure that's done by the end of this year to be in compliance. All right. I will be around at a table afterwards if you have follow-up on any of these or any other COVID topics. For now, however, I'm going to turn it over to my partner in our Los Angeles office, Laura Rutherford, who is possibly going to scare you with the many California updates, but you should listen carefully because as goes California, often goes the rest of the country, at least in many of the states in which I know you all do business. Laura, are you able to join in? Jessica, I don't know if you have any insight about, there she is.
Yeah, I'm here.
Perfect.
Hi, everybody. Thanks, Bridget.
Okay.
Hi, everyone. I'm Laura Rutherford. And as Bridget mentioned, I'll be giving you an update on the recent new developments in California. But before I start, I just wanted to quickly announce the Kansas CLE code for those of you seeking credit in Kansas. So just jot this down. The Kansas CLE code is LG, P like Peter, M like Mark, 1102. Again, that's LG, P like Peter, M like Mark, 1102. Okay, and we can get started. As Bridget mentioned, you know, part of my presentation will probably scare you. A lot of people ask me, you know, should we be doing business in California? And I don't know why this slide has become a moving target on the picture. It was really just supposed to be a static picture. But you know, I always tell employers, if you don't have to do business in California, you probably shouldn't, because as these slides will show, it is very difficult for employers to thrive here, and it's very easy to get in trouble. So the first change in California, which you've probably already heard about, is an increase in the minimum wage. If you have 26 or more employees, you're going up to $15 an hour, and the exempt salary threshold is $62,400. For employers that have 25 employees or less, then they're sort of going to be at last year's rates, $14 an hour, and a salary threshold of $58,240. And that's in order to qualify for the salary basis test for overtime exemptions. Okay, next slide, please. All right, this was one of the more offensive changes, I think, to California employment law. Essentially, the legislature has added a section to the penal code making the underpayment of wages a grand theft under the criminal paradigm, which is crazy to me. And if you see the sort of the definition of what you can get caught up in, basically it's the intentional theft of wages, including gratuities, so tips, in an amount greater than $950 from any one employee or $2,350 in the aggregate from 2 or more employees. By any employer in a consecutive 12-month period. That, as many of you probably already know, those numbers are very, very low. And employees in California allege, you know, underpayment of wages for a variety of reasons, rounding of employee time, off the clock work, you know, they didn't get a meal break. And so, you know, getting to that aggregate of $2,350 is going to be very easy in cases where an employer has a lot of employees and they might be missing minutes of time. Now, someone asked me yesterday, you know, what if it's an accident? Well, sure, you know, this law is not intended to punish accidents. However, if you look at the definition of what theft of wages is under this new provision, it is the intentional deprivation of wages, which is defined in the labor code. That would be anything from commissions to hourly pay, piece rate, etc. It also includes tips, as we just mentioned, or any other benefits by an unlawful means with the knowledge that the wages are actually due. And I find this provision extremely problematic because the standard of, you know, whether or not an employer owes money is basically if you know the employee is working and then isn't getting paid, or you should have known the employee would be getting paid, then you can be liable for those unpaid wages in the civil context. You know, I would assume that it is a heightened standard on the criminal side, but I think just the fact that there is a criminal component now to unpaid wages is very difficult to digest. You know, I also wonder if it's constitutional, but I guess we'll see. This law goes into effect January 1 of 2022. And as you can see, it's punishable as a misdemeanor or prison for up to 1 year, or as a felony in county jail for 2 to 3 years. There's no fine provision in this statute. And that's probably because you can be fined in many other ways under California law for underpaying people. So that's the first big change to California law. The second change, which is a little esoteric, and I was going to go through an example, but I know that we're pretty short on time. But essentially, there was a case that came out from the California Supreme Court this summer that dictated how meal and rest period premiums should be paid. In California, you have to provide a meal break, a 30-minute uninterrupted meal break within the first 5 hours of work, or within the first 10 hours for a second meal break. And that meal break must be uninterrupted, and then you must be duty-free, which means it's 30 minutes and the employee must take it and it must be provided. If you fail to provide that meal break, you're on the hook, the employer's on the hook for an extra hour of pay at the employee's, quote, regular rate of pay. And for rest periods, you might know the rule is a 10-minute rest period for every 4 hours or major fraction thereof of work. And the same penalty applies. So if a 10-minute rest break uninterrupted is not provided, or it's provided late, you know, the employer must pay an extra hour of pay at the employee's hourly, you know, regular hourly rate of pay. So the FARA case discussed what constitutes the regular rate of pay. For decades, that was just the employee's, you know, hourly rate. So if someone was paid $15 an hour and they missed a meal or rest break, you paid them, you know, $15. But for employees who might earn additional compensation, such as commissions or bonus, you now have to factor that commission or bonus into the penalty that you pay for the missed break. In a similar way that you would recalculate overtime, right? You now have to calculate the extra hour of pay by incorporating that additional compensation. I want to emphasize, only because I got a frantic call from a client on this, who said, do I now have to pay these premiums at the overtime rate, i.e. 1.5 times the employee's regular rate of pay? The answer is no. You're not paying an overtime rate. You're just simply incorporating extra compensation into the employee's regular rate when you pay that extra hour of pay. So we can go to the next slide. And here's an example. Just because we're short on time, I won't really break this down, but you're going to get the slides. And if anyone has any questions about how to calculate this, feel free to give me a call so we can move on. The next major change in California is what you can include in settlement and severance agreements. As you may have heard, if an employee files a claim for sexual harassment or sexual assault, you cannot require confidentiality as to the underlying facts of those claims in a settlement agreement. So that was a law that had changed a year ago. Now, the law has been expanded to further narrow both not only confidentiality, but also non-disparagement restrictions in severance and settlement agreements. So now, under the new law, any acts of workplace harassment or discrimination based on any protected category under FEHA is now covered by this, confidentiality prohibition. So for instance, now if someone files a lawsuit for race harassment or race discrimination or disability discrimination, you cannot require confidentiality in a settlement agreement as to the underlying facts of those claims. So now it's not just sexual harassment claims, it's any protected category under FEHA that has been raised. Next slide. You also cannot require an employee to sign a release or non-disparagement agreement denying the employee the right to disclose information about unlawful acts in the workplace in exchange for a raise or a bonus or as a condition of employment. You can still write in non-disparagement provisions, but you want to have some disclaimer language that states, as I've suggested here, nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination or any other conduct you have reason to believe is unlawful. So, as many of you might be aware, we typically include non-disparagement provisions in our settlement agreements, and the expectation is that these employees would not come forward and start discussing certain claims or complaints that they made in the workplace. Well, now we can't do that. And then if we are going to offer a severance agreement to an employee, you must notify the employee that he or she has the right to consult an attorney. We typically do this when we have ADEA releases, but now you have to do this in every case. And you have to give the employee a reasonable period of time, not less than 5 business days in which to do that. And look, at the end of the day, giving the employee this option is probably beneficial. I mean, sometimes it can be scary. They'll go get a lawyer and they'll ask for more money, et cetera. But in my experience, in a lot of occasions, these employees do talk to lawyers. Very little changes, and now you've at least got that extra insulation that the employee did consult with an attorney before signing the agreement, and it just makes the enforcement of that agreement a little bit easier. All right, next slide. This is just an easy slide. The government code has been, FEHA has been amended so that you're required to preserve personnel records for applicants' employees for 4 years from the date that they were created or after the employee was terminated or when the employee is not hired. And if you receive notice that a complaint has been filed by the Department of Labor for the state of California, you must preserve all the relevant records until after the complaint has been resolved or the statute of limitation has expired, whichever is later. Next slide. COVID notice. Many of you might have already been doing this if you're operating in California, but you need to provide notice to both employees and the state if there's been a COVID exposure at the work site. We won't go into the state requirements. There's a lot of forms that you can get online, but in terms of providing notice to employees, I think we get a lot of questions around this, and you may have resolved them already because I don't think the requirements are all that different in other states, but you want to explain to employees that they have been exposed. You must provide information about the benefits that they're entitled to if they need to take time off, and you must distribute it in a way that employees normally receive notice. So if you typically send emails, send emails. If you typically send certified letters, do that. But you don't want to be sort of, sending notice in a way that is designed that the employee won't learn that they've been exposed to COVID. You should not include the employees, the people who had COVID. You shouldn't put their names in any of these notices. And you must retain these notices for 3 years, which is important. And if you do have a workforce that is unionized, you must use Cal OSHA Form 300 and send that to the union or the union representative. Next slide. One of the changes that's coming in 2022, it was actually effective October 6th of 2021, but is to require employers when giving notice to the local public health agency of a COVID outbreak, you must give that notice within 48 hours or 1 business day, whichever is later. The new law will give you a list of individuals and entities that the notice must go to. And there are now an expanded list of employers who would be exempted from this reporting. And just for purposes of, in case you didn't know, that a COVID outbreak is defined as 3 cases within a 2-week period. And I think that concludes my session. It is difficult to be in California, but I totally understand if you want to leave. I'll hand it back over to Catherine.
Thanks, Laura. Thank you to all of our presenters today. I expect that you took some important things away from the time, and remember, we will be sending out the slides.